Hello, folks. I'm Brian Lawrence. I'm the CEO of the Seattle Public Library Foundation, and I want to welcome you to today's Plan Giving webinar. I started in the role of CEO of the Seattle Public Library Foundation in August, and we're really thrilled to welcome you all to our final webinar of 2024. Lisa Yamasaki from Seattle, the King County Library System Foundation was supposed to be here, but like many of you, maybe out in the audience, might be experiencing some power challenges. So King County's library systems are delayed in opening. So I'm flying solo here today, but I'd like to thank all of our partners from King County Library, as well as Snow Isle Library Foundation and Pierce County Library Foundation for being with us today, and hope you are all safe and warm in your homes. Um, every time we host one of these webinars, I'm reminded of just how important legacy gifts are to our libraries and their long-term sustainability. Anyone who includes an estate gift to a library is invited to join one of our organization's sort of member societies, like the Seattle Public Library Foundation. We have a legacy society, which gives you some nice little perks here and there. And I know King County Library System has a literary legends society. So as we go through this webinar, if you're thinking about making a gift to your library foundation, please check in with the staff, and they can tell you about what kind of benefits are offered for those programs. Our goal with these webinars is to make planning easy for you. And having been through estate planning with a parent, I know how it can be a bit tricky. And sometimes, the inertia of just getting started is a barrier. So our job and our goal with these webinars is to help connect you to the knowledge, the information, and the people that can help make your estate planning process a little easier. And I know this, when you finish your plan, it'll be an incredibly good feeling, an accomplishment to know that your affairs are in order. So congratulations for being here, and we're looking forward to sharing some great information with you. As for our libraries, we love talking about estate planning here at Seattle Public Library Foundation. I'm sure our partner libraries do as well. Our goal is always to just really, really make it easy for you, help demystify some of the elements of estate planning. Like, for example, here in Seattle, we have many people who like to start endowments as part of their estate giving. And one of our goals, and one of my goals as the new CEO, is to sort of demystify endowment giving, so people don't think it's like something scary or that only rich people do. Anybody can be an endowment donor if they so wish. So at the end of today's webinar, we'll have a couple names that'll pop up on your screen, and that's Jessica Carso from the King County Library System Foundation, as well as my teammate here, Kara McDonald, who normally operates these webinars. We're available, Kara's available, Jessica's available, and our friends at both Pierce and Snow Isle are also available to help answer any of your questions or lead you on the estate planning process. So a couple quick reminders. As Kara posted in the chat, we are recording this, so no need to take super careful notes. They'll be posted online, and you will receive a link to that afterwards. Our speaker will be taking your questions, so use the Q&A box, not the chat box. And when you see a question that somebody else may have raised, if you also like that question, click the little hand thumbs up sign to upvote it. And so that will give our speaker the chance to see kind of which questions are really rising to the top on people's minds. Finally, when you sign off today, after the last slide, there's going to be a survey that pops up on your screen. So we'd be super grateful if you could take that and tell us how we did, what kind of programs you're looking for in the future, and whether we can be of any assistance to you. So to sweeten the deal on that survey, we're going to offer a book bag for anybody that completes the survey. Or I'm sorry, we're going to do a drawing for a book bag. And so that'll be a fun way to get a nice collection of books that people love. So now it's time to turn it over to our speaker, and I'm thrilled to welcome Tiffany Gorton. For those of you who have been to our past webinars, you will have met Tiffany before. She is an excellent speaker. She's an attorney at KHBB Law. And a longtime fan. I also like to note that Tiffany is a fellow Michigander, so I know there are a lot of us here in Seattle that come hail from the Midwest. So I'm always there. You go. Me too. Tiffany, we're thrilled to have you back. Take us through estate planning essentials, and I'll be back a little bit later in the program once you've given your program. So thanks.
Thank you so much, Brian. And thanks to all of you for being here. And I just want to kind of echo a couple things that Brian mentioned. One, please, please, please respond on the survey because I've been working with Kara and with Brian and with the Public Library Foundation and King County Library Systems for several years. And in developing these programs, we really look at those comments to improve, to give more of what you want. And so that's really helpful to me as a speaker. Plus, there's an opportunity to win a bag of books. So please do that. And today we're kind of talking about kind of an overall, kind of a survey, if you will, of various estate planning topics that have come up either through webinars that we've done together, presentations I've given, questions that have come from audience members in prior presentations, and really kind of come up with kind of something for everyone, as Kara's email that came out said, and really thinking about kind of some of the barriers that you folks can feel with regard to estate planning. And I know Brian mentioned kind of working with a parent on moving through and navigating estate planning. There can be some tricky things, but the feeling of having that crossed off your list and how good that feels, that is 1000% accurate. So thinking about kind of some of those things, talking a little bit about some of the foundational estate planning tools, just as a kind of a refresher, and you can never hear it too many different ways, so to speak. We'll talk a little bit about some of the tax implications on some planning, and also kind of some of the details of probate administration, kind of what that is. Is it this big scary thing under the bed that we've sometimes been led to believe or not? So in terms of kind of moving forward, I'm going to share my screen so you'll be able to see my slides. All right. And just kind of, like I say, we're going to talk about kind of some of the barriers and some of the basics and how to make the right plan for you. All right. So at the outset, here are a couple of things to consider. And even before we kind of talk through the details on the slide, I know that for my clients and having done this for several years, thinking about even finding an estate planning attorney can sometimes feel like your Everest, or thinking about, oh, what do I have to know before I talk with my attorney, or before I set out to work up an estate plan. Or even completing the questionnaire once you identify a professional that you want to work with, if that's your plan. Completing the questionnaire that we send out, which I know can be can feel daunting, because you're thinking about who in my life could serve as the fiduciary. How do I want my assets to flow one day when I'm gone? Who could help me in the event of in like an incapacity circumstance. And some of those questions we're gonna talk through here today. But really, at the end of the day, I want to kind of give you a couple of key takeaways as we kind of talk about some of the broader aspects of this. But really, you just need to think about, what do I have? What do I want to happen to it? Where do I want it to go? And what's important to me if I were in a position of being incapacitated, and who could help me in those roles? So it's sometimes, like I say, in particular, filling out a questionnaire or thinking through the conversation of, oh, my life insurance policy, my bank accounts over here, and kind of even gathering, some of that financial information that, it might take an hour to kind of go through, all of your statements or things like that, but it can feel really overwhelming and daunting. And I know that to be true, but want you to kind of take a step back and think about, all right, there is kind of a bullet list to start with. And then, as you move through those conversations, get into more detail with your planner. So in terms of kind of thinking about from a broader perspective, thinking about some of the things at the outset of your estate planning discussions, importantly, and if you've heard me speak before, you've probably heard me say this. If you are incapacitated, who can you rely on to help with finances, with healthcare, if you have minor children? And I think that answering some of those questions is really kind of the most important piece of a solid foundational estate plan. You'll find that, we talk a little bit more about the tools here in a little bit. And this really gets to the durable power of attorney. But making sure that have a backup, so to speak, to yourself, because why I say that this is the most important piece is this is something that would take effect when you are still living. And that is more important than kind of where your things go, which, we'll talk about that as well. If you have a terminal illness or are in a permanent unconscious condition, do you want life support? Do you want those measures continued or removed? And that can be that can be really hard. That's hard for families. That's hard for an individual to think about for themselves. But really, I think thinking about from a global perspective of what's important to me, what does quality of life look like to me, and what are some of my values surrounding that, and that way you can think through who could assist in a circumstance like that, and how to communicate to them what is important to you to ensure that your wishes are carried out. Some other things to think about following death: do you want to donate organs, your eyes, tissues, your entire body, and does that include for medical research? There's a difference then between donating organs for other individuals versus medical research, and that is an important distinction. It's something that is important to some people, and you want to make sure that you think about what's important to you. And following death and any donation that occurs, how do you want your human remains treated? Do you want to be buried? Do you want to be cremated? In Washington, we have a lot of really good options. We have composting, we have aquamation or alkaline hydrolysis. What makes sense for you? Thinking about kind of moving from kind of our human body questions to thinking about more of the asset-based questions of, following your death, who's going to be your beneficiaries? Is that a makeup of, charitable organizations? Do you have descendants? Do you have children, grandchildren, other family members, siblings, nieces, nephews? Who do you envision benefiting from your estate one day when you're gone? And to what extent? Are there any beneficiaries in your life that should have their assets put into a trust? This would include, any minor beneficiaries. If you have minor children, minor grandchildren, or other minors in your life that are important to you, whether they're, related to you legally or not, wanting to make sure that any, minor beneficiary is set up for success in terms of inheriting assets from you. Does trust make sense for them? Do you have a beneficiary who has some specific needs that allow them to potentially qualify, if for certain government or other types of public benefits? That is something where maybe they qualify for Medicaid or they're on Social Security disability, something like that, or they could potentially qualify for something like that in the future. That is something where if you do have someone like that in your life, and you also want them to benefit from your estate, there is some specific planning that you can do to ensure that your generosity doesn't inadvertently kick them off benefits or disqualify them from benefits. And that is through the use of what's called a special or supplemental needs trust. That's something that can be built into a foundational plan. Do you have a beneficiary in your life that might struggle with addiction issues or, anything along those lines that could possibly put them in a position of maybe not being the best choice to manage assets on them for themselves individually? And in those circumstances, we can always develop something that's tailored for the particular needs of that beneficiary. So, thinking about, who in your life you would want to benefit, and what might make sense. And you don't necessarily have to come to the table knowing, here's the tool that I need, and here's the tool that I need for this person. And you can just, come to the table with the people that are important to you in mind. And also, some of the concerns that you might have wanting to ensure that they're set up for success in, with whatever inheritance they were to receive from you. And I think one of the things that mentioning that you don't have to understand or know or have identified the specific tool that you need to use. I think that that's another important thing to note with regard to, sometimes these potential barriers to estate planning in general is you think about the things, the people in your life or, who you want to benefit, whether it's, charities or individuals. And then sometimes it can feel overwhelming of, oh, but I don't know how to do that. And I tell clients all the time, I do this all day long. You don't. You're not expected to come in as an estate planning expert. You come in as, somebody who has individuals or charities that they want to benefit. And we talk through kind of the circumstances and, what makes the most sense and the best way to do that. So I tell clients all the time, you don't have to become a CPA, you don't have to become an attorney, you don't have to become a financial advisor, you don't have to be the expert. Let's talk through some of these things together. And that's really what we as planners are here for is to give you, options and discuss some of those tools and what might make sense given the specific circumstances. Some other questions to consider, following death, who can you rely on to administer your estate? And that is you'll hear the words executor or personal representative or administrator. There's slight variations in terms of that terminology, but for our purposes and for, general purposes, they're really used interchangeably. So if you hear those, you may even hear executrix, administratrix, depending on, what document or article you're looking at. We don't necessarily add that tricks at the end anymore, but we're thinking about the person who would administer the estate under that umbrella of all those terms. And what is estate administration is, filing your will with the court, making sure that, they inventory all of your assets, gathering assets, finding creditors if there are any, making sure that creditors are properly paid. We'll talk a little bit more later on in the presentation about the probate process and trust administration. But as you're thinking through, the people in your life, thinking about, who could you rely on to serve in that role? Who could you rely on to kind of run the business of winding up the business of life, so to speak? Who in your life might make sense? And some of us, this is something that clients look at more and more frequently is, whether you have children or not, because sometimes it feels like that, my oldest child is, the natural person to rely on, which may or may not be, accurate depending on your circumstances. But like I say, regardless of whether you have kids or not, a lot of folks are starting to move toward using a professional fiduciary to serve as executor, or serve as trustee or as agent under power of attorney. We'll talk about all those fiduciary roles in line with each of those tools, but just know that at the end of the day, as you're, again, kind of trying to overcome some of these barriers that we might, think are there in terms of starting that conversation, is there are a lot of really good options, particular here in our area, in Washington State, for folks that serve. They're professionals that serve as on those fiduciary roles. So it doesn't necessarily have to be a family member or a friend. Certainly can be, if it makes sense for your circumstances. But there are a lot of other options. There's big bank trust company, of course, but there are a lot of other smaller options that are, the expense is commensurate with the size of the operation, and they have, varying hourly rates for varying administrative duties. And so it's not just, a huge expense of, having a large trust company or similar serve in that role. And sometimes that does make sense, don't get me wrong. But I just want to point out that there are a lot of different options for who can fill those roles. And I'll talk some more about that as we think through some of the tools. So another question, where and how are you going to find a fiduciary? Where and how will your fiduciary find kind of your asset liability information? That's something where, making sure that you have, copies of your documents, your important papers, so to speak, in either your filing cabinet or a folder, or, a copy on hand, either, digitally or otherwise, that your executor or your agent, if it's under power of attorney, knows where to find those things. And so I say a folder or filing cabinet, which of course, makes sense for most of us. But a lot of times, folks are saying, we're trying to be a little bit more paperless, and I don't get bank statements in the mail, or I don't get whatever statement in the mail. And so making sure, like I say, that you have a digital copy of those things, and that your executor or your agent has access to those, or that they have instructions on how to get access should the need arise. Because as you think about this, if you whether you've served in any of those roles or not, you're really kind of dropping in to somebody else's life, so to speak, in terms of their finances and their day to day and week to week and month to month circumstances from a financial perspective. And that each of us knows kind of all the ins and outs of the bills we pay every month, et cetera. But of course, if you think about, okay, if I'm going to step into that role for somebody else, how would you go about finding those things? And so being somewhat organized and just, allowing that person to know where to find those things, I think can be really important. So I want you to pay your taxes. Just kidding. I want to save you taxes. So what about estate taxes? And we won't spend too much time on this, but I just want to flag this thing where, if you have $1 million life insurance policy, as we talk about these numbers, you want to make sure that that you're thinking about that as you're, doing some of this tax planning, and making sure that your advisors are aware of that, because it definitely can change the equation, particularly as you'll see here in Washington. So these numbers look at, again, global assets, bank accounts, brokerage accounts, retirement accounts, life insurance, real estate. So all of those assets. So in Washington, we have our own state estate tax, and it affects folks who die with assets totaling over $2,193,000. For purposes of conversation, I'm going to say 2 million during this discussion, because 2,193,000 is kind of a mouthful. But in terms of that exemption amount, it's been that number for the last several years. And at least at this point, in terms of where our legislation is, that does not get adjusted for inflation. So that's the number for 2024. That's the number for 2025 in the foreseeable future. But stay tuned to see if we can get that adjusted. With regard to the federal estate tax exemption amount, it's 13,610,000 for an individual, or 27,220,000 for a married couple. It's going to increase in 2025 to 13,990,000 per individual, and correspondingly 27,980,000 for a married couple. I heard another presenter speak about federal taxes a couple of weeks ago, and he was laughing like, why can't we just make it 14 million? So it'd be easier for everybody to say. But no, there's a formula, and these are the numbers that we landed on. So at the federal level, which is significantly higher than Washington, I joke that I hope to have a federal estate tax problem. I don't currently. But the Washington state estate tax can affect a lot of people, as you consider, even, I'm sitting in King County today. And so thinking about, the price of real estate, having a retirement account and a house in King County, or having a life insurance policy, that number is folks get to that number a lot quicker than sometimes we would think. And so if you do have assets that rise to that $2 million level, or with regard to the Fed numbers to, almost 14 million. Again, that's going to need to be taken into consideration in your planning, because there are certain ways that you can reduce your exposure to estate tax if that's something that's important to you. Now, question, what about after 2025? And obviously we're in November here, we're coming up on the holidays, and probably a lot of us are feeling like the end of the year is closer than we might like. In terms of our workloads, et cetera. But in any event, it's right around the corner. And so thinking about, what does this mean for 2025? What are those numbers? That's why I included, the federal numbers, which change, but then also what happens after that. So we're, coming up on, another calendar year, and you may have heard that there is a sunset provision in the current federal tax code. And so basically what's going to happen is if nothing occurs, if there's no change in legislation over the next several months before the end of 2025, then those large exemption numbers are going to revert back to what they were over 4 years ago. And so basically they're going to drop down to that $5 million amount, and they're going to be adjusted for inflation. So that means that at the federal level, the exemption amount will be probably around 7 million per individual. And of course, I don't have a crystal ball. I would be making a lot more money if I did, but that's what we know. And we don't know if there's going to be legislation to change that, if that's going to be kind of re-upped, so to speak, and we're going to continue with these larger exemption amounts at the federal level or not. Right now, what we know is at the end of 2025, they're scheduled to sunset. And so basically, if there is no legislation, no action that's taken to make any changes, then they're going to revert back to that 5 million adjusted for inflation. So that's something to consider, depending on, your asset level, if it makes sense to do lifetime gifting to reduce that number, which is a more involved conversation, but just flagging that for you. In terms of the estate tax, what does the expense and amount look like? So in Washington, it's between 10 and 20%. And as you can see, it's on this kind of graduated schedule, depending on what your amount of money, your exposure, or what amount of assets are exposed. And so again, I just wanted to kind of flag these things for you so that you understand, one, what the estate tax is, who it affects, and what the numbers are in terms of, how this could affect you or your heirs. And at the Fed level, it's between 18 and 40%. And as you can see, it's also graduated, but it creeps up, and we really say, you know what, it creeps up very quickly. And so we think about it as a 40% tax. Okay, which states have an estate tax? There are a couple handfuls of them, and I've listed them here. I get the question very frequently, as you can imagine, from clients of, well, what if I leave Washington? Which, even though I'm from Michigan, which I love, I've been here long enough to know, or at least to feel like there's no place better, and I can't imagine leaving. But sometimes folks will consider, what if I change, my domicile to a state that doesn't have an estate tax? So I put the slide in here just for food for thought in terms of who has an estate tax and who doesn't. And one thing I think is important to note with regard to the estate tax is this isn't something that I'm going to pay with regard to my own estate. You are not going to pay it with regard to your own estate, meaning I'm not going to ever write a check to the Department of Revenue or to the Internal Revenue Service for my personal estate taxes. This is something that occurs when I die, if my assets rise to those threshold levels. And if I have a surviving spouse, or if you have a surviving spouse, and the majority of your assets are going to go to your surviving spouse, whether that's outright or in trust, we have the unlimited marital deduction. So there's not going to be a concern in those circumstances, which is most circumstances where there is a surviving spouse, they're going to receive, the majority of the assets. In those circumstances, it's not the surviving spouse either that's going to write that check to the Department of Revenue or the Internal Revenue Service. This is a tax that is on, my assets on my estate when I'm deceased and when my spouse is deceased, but it's something that's paid out of the estate essentially before the final beneficiaries receive their share. So this is a tax that really, affects my kids or my heirs or my other descendants or my other beneficiaries. And shameless plug here, when you're thinking about your charitable giving, note that they're not affected by that estate tax. So if you are giving to charity largely, you can reduce or completely eliminate your exposure with regard to the estate tax. So moving on to the gift tax, and you'll note that this is the federal gift tax. It's important to note that Washington state does not have its own standalone gift tax. So there's a lot of planning that can be done here in Washington And when I say planning, meaning planning around eliminating or reducing estate tax exposure by making lifetime gifts. So, what is a gift tax? It is a tax that is paid by the donor. So, if I'm making a gift to my neighbor, I'm the donor, my neighbor is the donee. And if I'm making a gift, I'm the donor. Like I say, I would be responsible for any gift tax that's due. Again, there's not a gift tax in Washington, so we'll talk more about that as to kind of how the planning works here in Washington with regard to gift tax. But the Fed does have a gift tax. And so the question is, what's subject to that federal gift tax? Well, gifts from me, the donor, to other donees other than my spouse, because there's an unlimited marital deduction, and not to charities. There's a charitable deduction there. But if I make gifts to my neighbor or my niece or my kid, those are gifts that you want to look at and make sure, given the amount, whether they're gonna be subject to the gift tax or not. And it's important to note that, again, this is a federal tax. We talked about those large numbers in terms of the federal estate tax exemption amounts, which I'm just going to roll this back really quick. So again, that almost $14 million figure for individuals, and almost 28 for married couples. That is our lifetime gift tax exemption amount. And then, so if you gift up to that amount, you can gift up to that amount during your life before you have any exposure to gift tax. Then when you die, whatever's left in terms of the exemption amount that you haven't used, that's going to be your estate tax. So they're linked, is my point there. So you ask, so all that to say, lifetime gifts are not going to be taxable to the donor, the person making the gift, until they surpass that threshold level at the federal level. And again, no gift tax in Washington. So question, what about the $18,000 annual exclusion amount, or $19,000? That has been around for years. It used to be 15, and then it went up to 16, and so on and so forth. That increases typically every year. And right now it's 18,000. Next year it's going to be 19,000. So what that is your annual exclusion amount, meaning I could give in 2024 $18,000 to my neighbor before even starting to chip away at my very large, almost $14 million lifetime exemption at the federal level. And you can make that gift to as many individuals as you want. If you're married, you can double it for each individual. So if I am married, I can give 18,000 to my neighbor. So can my husband. So we're essentially doubling that gift to the neighbor to $36,000 before we even have to report that gift, or worry about chipping away at our lifetime exemption amount. One key thing here is thinking about medical and educational expenses, because that's sometimes where, for a family member or, a friend or something along those lines, where those types of gifts can come up. Maybe you're paying for college for, your child or your grandchild or some other, important younger adult in your life. Paying those expenses, making them payable directly to the educational institution, or the medical provider, that is not going to count toward your lifetime exemption amount. So for example, say that I'm paying for my neighbor's this year for college, and it's $50,000, 50. That would normally be something that's reportable as a gift, and it would chip away at my lifetime exemption amount because it's over my annual exclusion amount of 18,000. However, if I'm making that gift directly to the educational institution, then it's not taxable. It's not going to affect it's not going to reduce my lifetime exemption amount. What is deathbed gifting? That's where I say in Washington, because we don't have a gift tax, a lot of times we can use lifetime gifting, as a means to reduce our exposure to the estate tax at death. And one of those ways is through deathbed gifts. This is something where, what if you're ill, that death is near, and you have, assets above that threshold level, and you want to reduce your estate for estate tax purposes, you can gift them. And, you can gift them to your kids or your grandkids or your nieces and nephews, or, your family member, or your friend, whoever, is your chosen beneficiary or beneficiaries, you can make those gifts during lifetime in order to reduce your estate for estate tax purposes. And so that's something that comes up in those circumstances. Are all gifts created equal? A couple of things, and you might know this already just from kind of reading news or doing research in advance of this presentation, is thinking about gifts from retirement assets. And this is something where when you're thinking about charitable giving, it's important to think about, what assets, how do you get the most bang for your buck? And whether you're, doing this during life or at death, thinking about, well, I have a mix of individual beneficiaries and charities that I want to benefit. And say at death, for example, appointing an individual or designating an individual as a beneficiary on a retirement account, with that, that's very generous, but it also with that comes potential income tax exposure for that beneficiary. In the same way that when I take distributions from my retirement account in the future, there's some income built into each of those distributions, and I'll report them on my 1040, and I'll pay the income tax on the income portion of those distributions. Similarly, if I leave my retirement account to my individual neighbor, and then at my death, they inherit the account, and then they're taking distributions, they're going to have to pay income tax on the income portion of each of those distributions. That's not true for charities. So what I'm saying when I say how do you get the most bang for your buck, if you do have charitable beneficiaries, looking at all of your assets and how you want to benefit those charities, you can designate them as beneficiaries with regard to retirement accounts, and they don't have the income tax implication that individuals do. So that is a really good way to think about your beneficiary designations on those accounts. Similarly, if you're of an age where you're taking your required minimum distribution from your IRA, from your retirement account, again, you're taking those distributions. There's income built into those distributions that you have to pay income tax on. So during life, if you were to direct that those distributions go to your charity either in 1 year or in multiple years in a row, that the charity again will not have to pay the income tax associated with it. So you're getting a dollar for dollar benefit that the charity is receiving that even you yourself would not receive because you're going to pay income tax on that. Similarly, some people have highly appreciated stock. That's another asset where you can make a lifetime gift of highly appreciated stock to a charitable organization, and you get the benefit of having the full fair market value deduction on the value of those assets. But unlike if you were to sell those assets, you don't have to pay the associated income tax on that significant amount of appreciation, whatever number that may be. So just some things to think about as you're mulling over, what your assets are, who you want to benefit, and some ways that you might best benefit them. And again, you don't have to become an expert. These are just things to think about as you are thinking through that conversation and having that conversation with your planner. Okay, now getting into kind of some of the foundational tools. Again, I mentioned this earlier on when we were talking about thinking about who could help us in the event that we were incapacitated. So that's where your durable power of attorney comes in. And that document, I think, is the cornerstone of any foundational estate plan. Because again, it's important where your assets go, but I think it's most important what happens to you during your lifetime, or to me during my lifetime, in the event that I'm, incapacitated either for a season or long term, and I need some help with my finances or with my healthcare. We talk a lot about end of life decisions, and I think we think a lot about end of life decisions when we talk about durable powers of attorney, and that's absolutely true. This can be somebody who is authorized for healthcare, to authorized to make those decisions of, does Tiffany want life support or not? Does she want artificial food and hydration or not? We could talk all day long about bad things that could happen to our human bodies and not cover everything. But what we're doing here is thinking about, what's important to us, what does quality of life mean, and who could assist? Who can we put on deck, so to speak, in those scenarios where we might need some assistance? As we think about kind of who could make sense in that role for healthcare in particular, like I said, it's something that comes up with regard to end of life decisions, but it can also be a longer term commitment or a longer term position. Um, for example, even in my own life, my mom lived in Michigan just like I did. I'm here in Seattle and I'm an only child. So I was helping her for several years, making sure that, her bills were paid and, that her rent was paid and her taxes were filed and, doing all of those things that aren't necessarily end of life decisions, but are, assistance with, her financial life, also making sure that, she had her medical appointments in order and had her dentist appointment every 6 months for teeth cleaning and things like that, things that we do up for ourselves now, but in the event that we're all aging, and if we need help for either a season or for a longer term, thinking about who you could appoint in those roles for healthcare and for finances, if because that could be a longer term position. And it doesn't have to be the same person for healthcare as for finances. It frequently is and can be, but it doesn't have to be. And so if you have somebody in your life that you say, this person would be really great with regard to healthcare, but I don't think that they can balance their checkbook. Well, I'm just teasing, but it doesn't have to be the same person. We all have our own strong suits. And so what makes sense in terms of tasks for one person might not make sense for another. But as you're thinking about that, think about who in your life could make sense. Could that be, an adult child, a niece or a nephew, another family member, a friend? And again, I mentioned that there are a lot of good resources in our area for folks that serve, that are professionals that serve in that capacity, both for healthcare and for finances. And so if that's something, more and more I'm seeing folks who say, like I say, whether they have children or not, having, somebody in place that kind of knows that path, is very familiar with it. They've done it multiple times. They can have, really pointed conversations about your values and what's important. That can be a really good option for a lot of folks. And so know that that's something out there that can be a resource is those professional fiduciaries. Here's just the kind of notes of what's required. The document needs to be signed and dated, and it's either acknowledged before a notary or by two witnesses. The next document we're going to chat about is the will. So here we have a cat who he's getting 9 wills to fill out his 9 lives. But this is something that we're probably pretty familiar with. It doesn't take effect until we're dead. So we set it up during lifetime, sign it, put it in the vault, and you don't necessarily have to think about doing anything else with it other than, if life changes and you want to make updates. It doesn't take effect during your lifetime. But basically what it is a roadmap of who's going to serve as your personal representative or your executor at death, who's going to kind of take care of the business of winding up the business of life. And it also can name guardians for minor children. If you have minor children, you can, name guardians under the terms of your will, guardian and conservator, somebody to that the child would live with or would manage their finances in the event that the parents were not able to do that. Similarly, we can appoint somebody under the terms of a durable power of attorney for guardianship and conservatorship for minors in the event, like I say, that we're incapacitated for a season, making sure that that the little guys are taken care of in those circumstances. But moving back to kind of discussion of will, like I say, it's a roadmap as to what happens after death. So you appoint your executor there. You direct, which individuals, charitable organizations, et cetera, who's going to receive your assets, and whether that's 100% to one person or varying percentages to individuals and charities, or individuals only or charities only. Just kind of spelling out, what's intended there. And this is a very common tool in Washington. As I mentioned at the outset, we have, is probate a problem, or is that the kind of scary monster under the bed? I think is what I said. In Washington, it's not a particularly onerous process. And so the fact that if you execute a will, and then it gets filed with the court, and then there's a probate proceeding for the estate administration, that's not problematic. So 9 times out of 10, a will makes sense as the primary tool for a Washingtonian. We always talk about will versus revocable living trust as kind of the alternate roadmap tool, which we'll talk about in a minute. But by and large, this is the most common tool used in Washington. Again, that is true regardless of shape or size. We can do estate tax planning under the terms of a will, for spouses, etc. We can do planning for minors. So if you have minors in your life or folks that need, supplemental needs trust planning, we can do all of those things under the terms of a will. We can build in kind of those trust components, but we don't necessarily have to utilize a trust during lifetime in order to do that. So just know that as kind of a general rule is, for the most part, wills work well for individuals in Washington. It's a writing, it's signed by me, the testator. I'm making my will, the will of Tiffany Gorton, and it needs to be witnessed by two witnesses in my presence. The alternative is the revocable living trust. And I say alternative as kind of the foundational roadmap planning tool is what I mean there. In this document, different than a will, is really active during life. So what happens here is, we still outline, what we want to have happen after we're gone, who we want to receive our assets, who our beneficiaries are, individuals, charities. Are there going to be trusts for minors or trusts for, other individuals under the terms of this overall trust, this revocable living trust? But it is more of an active document during life because it's sort of a contract. And basically, it's an entity that holds your title to your assets during life while you're living. So if I were to use this as my primary tool instead of a will, what I would do is, I would title the name my house. Instead of it being, titled in my name, Tiffany Gorton as an individual, it would be titled in the Tiffany Gorton Revocable Trust. I would serve as my own trustee during life. It doesn't save you estate taxes. It's not that kind of it's not a tax savings vehicle. It doesn't save you income tax. You still, pay income on the sale of the real estate. You still, claim and report your associated expenses, etc. You still, if you have a gain, like I say, if you have a gain on the sale, you still are paying that capital gains tax. But so it's not a tax savings vehicle. It's an alternative to a will when circumstances warrant. And what I tell my clients is, sometimes folks I will recommend you consider it if you own real estate in another state, because, for example, say I have a place in Oregon, any state other than Washington, then you're in a position of your executor having to do a probate in Washington and a probate in Oregon to make sure that that property is transferred after you're deceased. Whereas if you use a revocable trust in that scenario, then you can title the Oregon real estate in your name of your trust and your Washington real estate or your other assets. And there's just one trust administration. There's not a probate here and a probate there. So when, like I said, probate in Washington in and of itself is not onerous in the way that it is in some states. For example, California, if you were from there or if you have friends there or you just read the news, there is a huge push for Californians. They always use a revocable living trust. They want to avoid probate. It's expensive there and it's a really clogged system. And so it's not that way in Washington. But if you do have, like I say, if you have real estate in another state, it can be more efficient to consider using a revocable trust. Similarly, at death, the will gets filed with the court. So there's no social security numbers or account numbers typically in that document. But sometimes folks like a little bit more privacy, or if they have somebody that they think would want to contest their will, or somebody who wants to make trouble for whatever reason. The revocable trust is not filed with the court. And so it doesn't become essentially a public document at death. And so that can be an attractive tool if, there are circumstances like that exist. But basically what happens under the trust is, like I say, you title the assets in the name of your trust during life. You still write checks, you still pay your mortgage, you still do all of those things. You don't, reap any tax benefits as a direct result of it being a revocable trust. But then at death, what happens is your successor trustee that you appoint under the terms of your revocable trust, then they come along and can administer the trust assets and under the terms of the roadmap of, here are my beneficiaries, here's the amounts that they're going to get, et cetera. They would come along and make sure that your taxes are filed. They'll make sure that, if they need to sell real estate, they'll do it same way that they would do it under the terms of a will. difference in it's really in, like I say, in Washington, it's kind of five or six of one, half dozen of the other, is that you're either doing a probate, which is an estate administration that is through the court. We're going to talk about that in a minute, or you're doing a trust administration under the terms of the trust. So either way, you have to do the fiduciary has to do the administration. It doesn't just automatically transfer, so to speak. There's still some steps that have to be taken. It's just whether you use the court as the forum or not. And it can be it's not necessarily more efficient or cost effective one way or the other, unless, like I say, you start to get into having multiple probates in multiple states due to real estate ownership. Okay, so what is probate? Because that's something where, well, what is this, this procedure? It is a court supervised process of settling a decedent's estate. So basically you're settling the debts, you're finding the assets, transferring those assets. File the decedent's final tax return, their final income tax return. If there's an estate tax return due, you'll file that return. Again, you don't have to become an expert. You don't have to become a CPA suddenly or become an attorney in order to prepare those returns. You can work with a CPA or an attorney in preparation of those returns. You don't have to do those things all yourself as an individual. But I say court supervised, but it's basically what happens is you file the will with the court opens the probate and gives the executor the letters testamentary, which basically is a one-page document that indicates to third parties that that person has the ability to manage the assets of this deceased individual. And the court, unless there's adversarial nature or other circumstances, most of the time 9.9 out of 10 there's not going to be any court involvement other than that initial opening the probate. And then once you're finished, all the assets have been distributed, taxes have been paid, creditors have been paid, then you file a declaration of completion with the court, and then the probate's closed. So although it's called court supervised, it's not as though you're going back and asking the court in a typical scenario repeatedly to sell the house or transfer an account or anything like that. Right. So what does that executor do? They gather the assets. They notify creditors that the person has died, file tax returns, and then ultimately make distributions according to the terms of the decedent's will. The person dies without a will. They make those distributions according to the intestacy statutes, which provides that our legal heirs, the decedent's legal heirs, receive assets. So depending on if you have a spouse or kids or parents or grandkids or siblings, there's statutory direction if you die without a will. So all of us has an estate plan, whether we have executed one or not. There's a plan for distributing our stuff. So what are non-probate assets? So these are things titled as joint tenancy with right of survivorship, property that's subject to a community property agreement, property held in trust, life insurance policies, transfer on death or pay on death accounts. These are things that typically are not going to pass through a probate. So for example, you go to the trouble to set up a will and you direct that, your assets are split 3 ways between A, B, and C charities. But then you have the bulk of your assets are in your bank account or your brokerage account that's titled as joint tenants with right of survivorship with your neighbor or your oldest child. Then at death, what happens to that account? It's going to go to the designated joint tenant if there's rights of survivorship there. So they become automatically the owner. And this is something I have done a lot of trust and estate litigation as part of my career. And a lot of matters come up where there's an account that is, maybe it's just a checking account, but it's titled as joint tenants with right of survivorship with one child, but the decedent had 3 kids and wanted things to be split equally according to their estate plans, according to their will. But this large account is going to go all to the child who's local because they were on the account as a joint tenant with right of survivorship, which may have been unintentional in any of those circumstances. Oftentimes, banks will automatically use that nomenclature or that titling when you set up an account. So just as a food for thought, cautionary measure, make sure that if you do have an account that you want titled that way, that's fine, but make sure that you intend to do that. Because it's not going to pass under the terms of the will. It's not going to go through the probate process. It's going to pass by a contract, whoever that surviving joint tenant is. Property subject to a community property agreement. So sometimes married couples will have what's called a community property agreement, where they basically are making their assets community and then directing that their assets go to their surviving spouse. But the issue there is, after the death of the second spouse, where do the assets go? So that would be governed by the terms of the will. Property held in trust, even in a revocable living trust. That's why that's a probate avoidance tool, is because if you title your house, your accounts, etc., in the name of your revocable trust, then there's not going to be any probate required to administer those assets. It's going to be administered under the trust administration. Life insurance policies, remember I talked about the fact that they're counted for estate tax purposes. That remains true, but they're not necessarily a probate asset because they can have a beneficiary designated on them. So, my estate plan has assets flowing to A, B, and C charities, but my life insurance policy goes to my neighbor. Well, that life insurance policy is not going to be part of the estate, so to speak, for distribution to under the terms of the will. It's not going to be a probate asset. It's going to go to my neighbor by a contract. Similarly, transfer on death or pay on death accounts. Those are like any bank account, brokerage account, etc. If you designate a pay on death or transfer on death the beneficiary on those accounts, then they will pass directly to that named beneficiary or beneficiaries at death. They're not going to go through the probate process. So all that to say, there's a difference. Just because you execute your will doesn't mean that all of your assets are going to flow under the terms of your will. So making sure that in conjunction with your planning, executing a will or a trust, that you also are double checking all of your accounts to make sure that they go where you want them to go, so that your plan works overall, that you don't inadvertently have assets going someplace else that you want to flow in the under the roadmap of your will. Okay, when to consider updating your plan. So I've just got a couple photos here. I tell clients that we plan for immediately for today, plan for as far into the future as we can see, so that we have flexibility and we don't have to be updating multiple times a year in terms of our planning. We do, like I say, we plan for today, but also as far into the future as we can see. However, there are times when you want to update. That just is kind of the nature of life, so to speak. So here we have, kind of weddings, babies, funerals. If you have a large liquidity event, you sell your startup, you have a large payout, any, kind of influx of capital or influx of an increase in assets, you receive an inheritance, and sometimes just the passage of time. For example, the first estate plan that I worked on when I graduated from law school, which was years ago now, was for my in-laws. And I told my husband, I said, it's a good thing I updated your parents' plan, because you would have had to go live with your Aunt Kathleen if something happened to them, which, of course, he was an adult. We were married. He wasn't going to have to go live with his aunt. But it's just illustrative of kind of the passage of time. They hadn't updated since their kids were minors. And that's not unusual. So when you're thinking about these things, you don't have to have this top of mind, constantly. It doesn't have to be, on your to-do list or part of your mental load, but just thinking about, hey, if I have a big life event, or my kid graduates from college, high school, or, as we all get older, and life changes, making sure that you at least think about, should I revisit my plan? Does this reflect my current intention? And sometimes the answer may be no, you don't need to make any changes, but just thinking about, like I say, ensuring that it reflects your current intent both now and, in the future, when you're thinking back as to if there should be any updates. So with that, I am going to move to some questions here. You can see those in the chat. Oh, there's a bunch. Great. Oh, this is a great question. Okay, so I'm looking at everything that kind of got voted to the top. So that's the order we're going in here. Can you explain what a disclaimer trust is? So that's a great question. When I mentioned that we have the ability under our will or our trust to do some estate tax planning, and I also mentioned that there's an unlimited marital deduction for spouses, the disclaimer trust kind of fits into kind of that kind of category of discussion, in that, for example, something happens to me, I die, my will says 100% of my assets go to my husband. So then say that I have $4 million in assets, because that number effectively looks at both of our respective Washington exemption amounts. So I die. My husband owns his half already, so my half of the assets go to him outright, and then he dies, the next day. So he dies with $4 million assets in his estate. Um, he only gets to use his exemption amount in Washington. So basically, he has 4 million of assets, but he only gets to utilize his $2 million exemption amount under Washington law. So he still has about 2 million that's exposed to the estate tax in Washington. Rewind the tape. Under my plan, I say everything is going to go to my husband, but if he takes the opportunity to disclaim assets into a trust for his own benefit, then he has the ability to do that. So same scenario, I have that disclaimer language under the terms of my will. I die, then my husband can look at the circumstances and say, okay, now I have $4 million in assets. The Washington state estate tax exemption is 2 million. I've got $2 million of estate tax exposure. I'm going to disclaim that Tiffany's share into a trust for my own benefit. He would serve as his own trustee. He would have access to those assets during life. He would still continue to utilize them. He wouldn't be hamstrung in any way. But then he dies. He has utilized my $2 million exemption amount by disclaiming my share of the assets to that trust for his lifetime. He has $2 million in his own name, so he utilizes his own estate tax exemption amount. So there's not going to be any tax due. You see, first scenario, assets outright, there would be tax due, there would be exposure. The second scenario, where I include that disclaimer language, he has the option to assess the circumstances and make a determination of if it makes sense to disclaim those assets or not. He did in that scenario, so that eliminates that estate tax exposure. The other scenario, which we use very frequently, because as I say, in Washington, that exclusion amount you can creep up to it very quickly. We often will use what's called credit shelter trust language under the terms of our wills or revocable trust for surviving spouse. So that same scenario that I gave with my spouse, but my will says my share of the assets automatically go to trust for my husband. It doesn't give him the option to assess the circumstances and then disclaim, because the problem sometimes can be you have to do that disclaimer within 9 months. Sometimes people don't think about it, or they're busy grieving or doing other things, and then they have to actively take a step to disclaim into the trust. So sometimes it makes sense, sometimes it doesn't. Just depends on the circumstances, but that's how it works. There's either outright gift to spouse, there's that credit shelter trust where it automatically goes, and then in that scenario, there would be no estate tax at the death of my spouse, or there's the disclaimer circumstance, which you asked about specifically, that gives the surviving spouse the option to disclaim into trust for their benefit or not. And, say for example, we have 3 million in assets, and then, we spend a bunch, and then I die and we only have 2, or we only have 1. Then in that scenario, it probably doesn't make sense for him to disclaim into that trust unless there's a significant anticipation of growth on those assets. So that's it gives the surviving spouse the opportunity to assess the then existing circumstances and law before funding a trust. What do you think about naming my financial broker as a third party to administering my trust? I think that could absolutely be something that's appropriate. The thing that I would say there is just double check with that financial advisor with regard to their licensure, because sometimes they're able to serve in those fiduciary roles and still kind of manage the assets or have the assets under management, sometimes not. So that's a question to make sure that they're not disqualified from acting in that role. Okay. Can you please list the essential items to complete to ensure the end of life safety for spouse and family? So in that scenario, I think making sure that you have an updated power of attorney for healthcare and healthcare directive that describes, what you want in the event of end of life decisions, meaning life support, artificial food and hydration, those things. But also knowledge is really power. And so what I say in terms of kind of how I draft for my clients is making sure that they have a person appointed. So oftentimes that's a spouse, and then they have a successor. They have a person appointed as their agent for healthcare, but they have the awkward conversation about what is important. what does end of life, what does quality of life look like to me? What are my values? What's important in terms of my abilities day to day that I would, want to be ongoing in spite of an illness or a long-term illness or not. And so kind of having those discussions about what's important and what's not, I think is really the primary way to ensure that, there's safety and security at end of life, and that the proper decisions are made and executed on behalf of that individual that's in this scenario would not be able to take those steps on their own. Okay.
Tiffany, I'm going to jump in here because
Okay.
we've got a new sort of upvote feature on the Zoom, which you may not be seeing, but I see a couple questions here that I think would be good for you to address
Okay.
that have gotten a lot of upvotes. One is a document called a transfer ownership of home on death. And the question is this necessary in Washington?
Oh, yes. Okay, that's a great question. So we have what's called it's a transfer on death deed. So essentially, during your lifetime, you can execute a deed that provides that your real estate. So, for example, my house, I execute that deed and I record it, and it says that the property is going to be transferred to my neighbor at my death. And so then it affects an automatic transfer of that real estate at my death. That is something where in practice, I don't use it. I don't think that I maybe have had like one client where they were single, had one child, and the property was everything was very clearly going to go to that one single child. And in that instance, it did make sense for them to use that, but it can, I've seen the effects of it not working properly or having some unintentional consequences that have come up. And so I would say it can be a tool, it can be an appropriate tool, but just make sure that you're looking at kind of the overall big picture of what your creditors are going to look like, what your other assets look like, and what your intentions are overall before executing something like that. Because I've found that a lot of times it does come, um, it, it can be without the advice of counsel or without kind of thinking through all of the big picture components.
And another question that we hear a lot on these webinars is about tools, the free tools that are out there, such as
Mhm.
freewill.com. So share your thoughts as an attorney on those types of options.
Yes, that is a great question, and I get that question a lot. So you do not have to hire counsel to set up an estate plan. You saw my slides that talk about durable power of attorney and will and what's required. Attorney is not required on any of those. That being said, my late law partner Tim used to say, "I could wire my own house, but I want to live there." So that's a little bit of a tongue-in-cheek way of saying I think that there can be a useful tool for some individuals, but I would say that they need to have a significant measure of caution as you're working through those, because there are some questions and discussions that your attorney would have with you, that is different than simply, answering questions and doing a drop down menu on freewill.com or similar. And I sat through a presentation once where a friend of mine had all of her staff use various free options or even paid options, but were basically, kind of do it yourself options for creating an estate plan. And she wanted to see, unprompted, how that would go and what kind of issues would come up. And some of the things that folks wouldn't consider necessarily are second marriages, for example. So if my spouse and I are married, we don't have kids together, but we have children from prior marriages, but then I die and I leave everything to my spouse outright, then in that scenario, I've inadvertently cut out my children from my prior marriage. Whereas you can, think through some planning and utilize, some trust planning for the benefit of the surviving spouse during their lifetime. And then, if there's anything left, your share can go to, children from a prior marriage. So there's some circumstances that come up like that can be a little bit nuanced, that I would say, if you're going to use one of those online resources, make sure that you're thinking about those various scenarios of, what if and who would inherit, in all these various circumstances to ensure that your long-term intention is affected. The other example that she gave is someone had problem, and I've run into this before with other online interfaces, not necessarily estate planning software, but the drop down menu is in alphabetical order for the state. And so although I'm a Washington resident, although this person was a Washington resident, what's the first state?
Washington, D.C.
Alabama.
Oh, yeah.
So, well, yeah, sometimes Washington, D.C., but Alabama. So you click the drop down menu, you got all the A's, all the stuff through, A through W. We're pretty far down on the list. And so they had drafted documents that comported with, I think that it was Alabama in that scenario with Alabama law, but they were not an Alabama resident. So, which, could have worked. So you can definitely get something that will work in terms of your plan, but you want to make sure that it will work best is kind of the caution there.
Great. Well, Tiffany, it's 12:10, so we're going to wrap up here. As always, I just want to thank you for just providing so much great information. You do this as a gift to your libraries, so thank you for taking your time, which we know is valuable, to share it with all of us. And again, we're gonna make sure that this recording and these slides are available to everybody who has been here and those who even signed up for it. So I'll look for that soon. So thank you again, Tiffany. And then I'll just say personally, again, based on my experience working with my parents' estate plan, hiring an attorney, they make it really easy for you, and they take the time to answer questions, and sometimes they offer flat rates. So it's really, I like to demystify working with a professional as well, because I think you can get good advice. So thank you, Tiffany. So
Thank you.
as we close, just a reminder that when we shut down here, you'll be prompted for a quick survey. Everybody who completes the survey will be entered to win a book bag from their library. So please do take a moment to share your thoughts. And as you think about your own legacy planning, please remember that a bequest or a gift to charities that are important to you really mean a lot. And we are grateful when you support nonprofits that you love, of course, including your libraries. And all of our participating libraries who are on this webinar, we offer great language that you can share with your own attorneys that can sort of help you designate your gift in the way that you want to have an impact for the future. Again, we'll have that survey. So please do let us know if we are ever included in your plans, so we can ensure that your wishes are documented. And we're also here to help. So if you have questions about how you can work with the library to make a bequest, please let us know, and we'll give you support and advice as your charitable partner. And then lastly, I'd be remiss if I didn't remind everybody that we are now in the November and December timeframe. So it is the charitable giving season. So please remember to support your library. Giving Tuesday is December 3rd. And I know that Seattle Public Library, we have a $50,000 challenge match on tap for our supporters, thanks to our wonderful board of directors. So check out your libraries during the end of year giving season, especially Giving Tuesday and December 3rd, and make a gift if you are in a position to do so. And then lastly, I just want to say, as I was listening to Tiffy, I went through that participant list and I saw a lot of really familiar names of people who have been helping our libraries for so many years. So I just want to say thank you all for caring so deeply about providing access to books and knowledge and information for all. We're incredibly grateful. So if you have any questions or would like to continue this conversation, let us know. But again, thank you all for coming out today. Stay safe, stay warm, and we will see you soon. Thanks so much.